morning. I have Catherine here, Catherine Miller-Spenlove from Reese Law. She's here with us today to talk about wills and estate planning. Hi Catherine.
Hi Teale, thanks for having me.
No problem at all. Can you just briefly tell me a little bit about your career?
I've been a solicitor now for almost 10 years. I grew up a bit west of Dalby and then went to university at UNE where I did a law and psychology degrees. And then I've been practicing Sydney for quite a while. Then I moved back. I was a barrister there for 3 years. I also worked as an in-house counsel, so I've got quite a varied career.
Very active career.
But now I've moved back to Toowoomba and I'm really enjoying the work. I do estate planning, property law and also business law.
Oh, wonderful. And can you tell my clients a little bit about wills and why it's so important?
Will is really important. A will is probably what most people associate with estate planning. Wills are, I think, most important because where you've spent a lifetime, amassing assets and, you work hard for your money, you want to make sure that it goes to the people that matter to you when you finally pass away. Now, there are rules around passing away without a will, but it doesn't mean that things will go where you want them to. So particularly for people that have assets, like people that have investment properties, it's even more important to make sure you have a will. Outside of property, there's also things, if you have children, you'll want to make sure your children are cared for by the people that you want. And you'll want to set your will up in a way that hopefully can avoid your will being contested.
Okay, so wills can be contested. Is there ways around that at all?
There are some ways to deal with it if it is contested. There's no guaranteed way to stop someone contesting. At the end of the day, certain people, such as children, have a right to contest and there's no way you can get around that. But you can set your estate up in a way that can make it very difficult for people to contest. Now, a couple of those ways are to distribute property or assets before you pass away. So I know a lot of people invest in properties plan to, they might have 3 properties, 3 children, and they'll give them away to their children. Or you can transfer them into joint names, so joint tenants versus tenants in common, which means when one of the owners passes away, the property automatically goes to the other, and therefore it doesn't even go through your estate. So even if your will is contested, it doesn't form part of your estate. Now, the downside of those 2 options are that you have to pay stamp duty on the transfer, so that can be expensive. But it is an option where you are concerned about your estate being contested. There are a few exceptions. For example, you don't have to pay stamp duty where it's a rural property that's used for primary industry, such as a family farm that's been in the family for generations. You can transfer that down to your children if they plan to continue farming on that property, but there are very limited exceptions. The other thing that you can do is you can when you're actually drafting your will, you can put in place some statutory declarations or affidavits which explain why you've made your will a certain way, why you may have left someone out, and it's also really smart idea to discuss it with your family. If you have, say, given 1 or 2 children essentially their inheritance during your lifetime and they accept that, it can be good to have a family meeting and to say, look, this is my plan for my estate, this is why I'm doing it, and get everyone on board with it at that time. So those are some of the ways that you can look at protecting your estate from a challenge.
Okay, wonderful. Well, thanks so much for your time today.
No problems, thanks for having me.
That's okay. Thanks for watching, everyone, and I'll have Catherine's information below on this email. Have a great day. Bye.
Bye.